Hello again, this is topic 4 of module 1. We're making good progress. Now in the last topic I gave you an introduction to planning law in Australia generally. Today in this topic I'm going to focus a little bit more on planning law in Queensland. Still in the introductory phase, I'm going to give you a bit of an historical overview of how planning law's developed, especially in the last 20 years in Queensland. And you can see it's not been a quiet or dull time. From 1936 till 1997, planning operated under the Local Government Act. That's a long period of time. Then in 1997, we had a radical overhaul of planning law in Queensland, and that introduced the Integrated Planning Act, which is substantially what we're dealing with still today. But since then, we've had another major overhaul or revision, which was in 2009, the Sustainable Planning Act. We had a Sustainable Planning and Other Legislation Amendment Act in 2012, which was also quite significant. And now in 2016, we've just had enacted the Planning Act 2016, which will come into operation next year. You can see that the nearer to the current time we get, the more change there is. I think it would almost be fair to say that change is constant. Whether we regard this as damage control on the Integrated Planning Act, or whether we regard this as fine-tuning, and whether we are actually there yet, are matters for debate. Okay, why have we had so many reforms? Okay, well, here's the philosophy that got it all going way back in 1997. This was the Director General at the time the Integrated Planning Act was created. He argued that clean, healthy, well-functioning cities which offer employees a high quality of life will influence the location choices of corporations. In short, Queensland's planning and development legislation will increasingly influence its economic performance. I think this was an instrumental planner here. He really believed that the law would make a difference, that we need it to drive good economic and environmental quality of life in Queensland. So he was putting planning first and foremost as the business of government. He was a planner. Okay, so how can we achieve all these marvellous things through planning? Well, the main reforms in the IPA, and sometime during this course you should read that little article. So you can see it's only 3 pages about the Integrated Planning Act. Not because the Integrated Planning Act is still in force, but the reform agenda is still what we're operating with today, and it's an interesting little piece. Okay, main reforms in the IPA. We are still they're still in the legislation today, so I will just mention them briefly. You can read about them more in the required reading that I've set for this topic, so make sure you do that at some point. It will give you a really good background. We have an integrated development assessment system, and you saw in the last topic how we've attempted to integrate both state and local government decision making into the one system across a really, really broad range of development and land use matters. Okay, more about that in weeks to come. We call that the IDAS. Infrastructure charging. One of the main reforms here has been to encourage councils to put their method for calculating infrastructure charges into a clear and transparent policy, now heavily regulated by state requirements, so that everybody will know in advance what sort of charges developers are up for. Private certification. This was in line with the microeconomic reform agenda, opening up the market, getting local government less involved in service delivery, more involved in policy. You can read about all that in the required reading. But private certification was to allow neighbouring local governments or private professionals to do some of the work of local government in assessing and approving the smaller and simpler types of development application. Ecological sustainability, again still with us today. This was in response to initiatives such as the Brundtland Report, the National Strategy for Ecologically Sustainable Development, where we've embraced throughout our legislation, certainly throughout our environmental legislation, a notion that development should be subject to environmental sustainability requirements. We'll talk more about that in the next topic. And again, performance-based planning. I did introduce that to you in the last topic, and I've just recited a definition for you here, or a description. Planning schemes identify the outcomes to be met and the impacts that must be addressed, but they should not prescribe the type, size or height of development that is allowed. So nothing too prescriptive in our planning schemes, in our regulatory planning schemes these days. The invitation was to get creative, be flexible, put your best foot forward and your best designs forward. We'll see some of the implications of that that have occurred over the past 20 years over future weeks. Okay, there were some issues identified with performance planning. Perhaps it's a bit too early to introduce these here, but you can see that this system lacks some of the certainty, creates a lot of discretion, may be hard to draft, and it may actually be less transparent and accountable than a more certain regulatory approach. We might talk about that again further down the track. But all in all, if we think about the IPA, it was Yearbury's assessment, remember he was the main reform protagonist, that the IPA provides a toolbox, so it's a framework piece of legislation to achieve desired outcomes. So it was all about driving the best possible planning outcomes. It allows us to move away from the preoccupation with process and inconsequential detail. It's designed to deliver substantial benefits in terms of creating a better business climate for investing, again appealing to that kind of micro-reform economic agenda, while at the same time requiring environmental conduct commensurate with community expectations. So a very rosy picture for the IPA way back in 1997. There were some critics even at the time. One of them was this guy Moon, who was also written another really short piece that's referenced in your materials. You might have a look at that. I wouldn't go into the detail anymore, but the criticisms are really good and really poignant even today. He says, by removing regulatory structures, forcing decisions to be made within very short times, minimizing third-party appeal rights and reducing opportunities for the public to contribute to the development strategies of a region, the IPA seems set to enhance environmental conflict and social disharmony. Wow, that was an interesting prediction 20 years ago. Has he been proven correct? That's something we'll talk about over the next few weeks. Okay, what else was wrong with the IPA? Because as you can see, we no longer operate from the IPA, we operate from the SPA. Well, everybody said, or many people said, that the IRAS was too complicated. Remember, that was the rolled-in referral and assessment system? Way too hard. Local governments were struggling with it, and they couldn't cope as assessment managers. Referral agencies could cope even less capably, and they were too slow or gave conflicting advice under the IDAS, the Integrated Development Assessment System. Not just in that development assessment, planning schemes were too cumbersome and costly to prepare. Well, this is what you get when you want to make super schemes that are comprehensive, holistic and integrated, but everybody complained about it. Anyway, coupled with that, we find that in Queensland over the past 20 years, there has been runaway urban development, especially in the southeast. So, you know, the legislation's got a big job on hand. And one of the other things which was identified in the IPA was there was actually a lack of proactive management by the state. And when you've got a case of runaway development, especially in the southeast, that might not be desirable. So, taking all those issues into account, we had another reform initiative. That one was from, it's cited there, the Planning for a Prosperous Queensland discussion paper in 2007. Okay, they came up, I hope you can read this okay, they came up with some new reforms to go into the Sustainable Planning Act, which while it is kind of modelled on, and you can definitely see it follows the IPA, so it's not a radical reform. It did introduce some major reforms, so they scrapped the IPA and said we'll call it the SPA now. Okay, the three key areas, you can read about this more in the materials that they developed, were the idea of proactive management by the state, including more emphasis on state planning provisions, including some regulatory areas, and a clearer hierarchy of planning instruments. So if your local planning scheme, was in conflict with the state planning policy, it had to be read in a way that was consistent, or you had to give priority to your state planning instruments. So rules about that. Rules about uniformity and consistency. Now this was interesting. This was your state planning provisions, the Queensland planning provisions. They were a framework for crafting your planning scheme. So they didn't really tell you, they had, a uniform types of zones and uniform definitions for your standard land uses. So this was really helpful because I thought you could just pull out a pool of what you wanted and put them into your planning scheme. Okay, so that was the Queensland planning provisions. We'll talk about them more in the next module. And then the other area of improvement or reform was to go further down the track of risk-based assessment. So if you had a really a simple application, it might now be assessed through a private certifier as a type of compliance assessment, just to make sure you're ticking all the boxes on the relevant very simple and technical codes. If you were in that area of code accessible development, you might be able to get a deemed approval if local government hadn't acted fast enough to consider your case and set conditions individually. So those were some efforts at speeding up, simplifying, where appropriate, the development assessment system. Okay, well, the SPA lasted even less duration than the IPA, and we get to 2015, and there are criticisms of the SPA. It's apparently, as we are told in the Better Planning for Queensland discussion paper, it's difficult to understand and use. Wait a minute, not the SPA per se, but it's difficult to understand and use some current planning schemes designed under the SPA, incorporating those Queensland planning provisions. There's angst about the length of time for planning schemes to be made and changed because they've become so cumbersome and huge and comprehensive. Decision making about development assessment is focused on the process and not the outcome. I think that was possibly a big complaint. The length of time for some development applications to be assessed. Haven't we heard these before? Wasn't this so in 1997 and in 2005? Throughout the time. Length of time for some development applications to be assessed, poor quality of some on-the-ground developments, and it was difficult to understand and use the legislation and its many related instruments. I think that was the key one they were getting at. As I've sort of intimated before, the SPA is a very big piece of legislation. I think I've got something here which I can't quite see. 1,041 sections. I'll give you more detail on that in a few minutes. So, where are we at? Why do we now have a Planning Act coming in 2016, and what's its goals? Okay, the goals are for the Queensland Government to deliver a better planning system, once again, that enables responsible development and delivers prosperity, sustainability and livability. This is almost the same words out of Yearbury's mouth 20 years ago, for now and into the future. So it's good that they know what they want to achieve, I guess. We believe that planning reform can deliver a more efficient system that supports investment and jobs, just like Kevin Yearbury did 20 years ago. But don't believe this must come at the expense of community participation or the role of local government. Well, that's good news. There was this is the 2015 under the Palaszczuk government. There was prior to that another discussion and reform proposal called Planning for Queensland's Development, bill I should say, not really act, it never became law. And the idea there that it would focus on facilitating the economic growth and prosperity of Queensland for an efficient, effective, integrated, transparent and accountable system. That was under the Newman government, slightly more commercial, business-oriented agenda there, but to a large degree, a lot of consensus, a lot of bipartisan support for reforming planning law and what we want to achieve out of it. So we will talk more, there's 2 more slides, we will talk more over coming weeks about what's in the Planning Act, but you'll see, again, not huge or radical reforms, even though sufficient to repeal the Sustainable Planning Act, which will, not now, but sometime next year will happen, and replace it with a whole new Planning Act, which is quite a different look and design. The idea is there to reduce complexity and duplication. For example, we've moved from 4 state planning instruments down to 2 state planning instruments, so we'll talk about that in the next module. In general, the whole guiding philosophy of this new act, the Planning Act, is to move procedural detail into guidelines. Some people feel unhappy about that, some people feel it's a big clean-up of the legislation itself. It makes it much more user-friendly. There are some improvements to public accountability, changing the cost rules for litigants in the PEC, really just returning to a pre-2015 rule that people coming to the court in the Planning Environment Court pay their own costs. Also requiring councils to give reasons for their planning decisions. We'll talk more about that in future weeks. I'm a little bit sceptical myself. Simplifying code assessment, a few initiatives there, and some minor technical changes. Again, you'll hear more about this over the next few weeks. The one I think that I should draw your attention to right now is that we are simplifying planning law by removing procedural detail into guidelines, because we want to, simplify and streamline and make it easier to use and easier to understand. Now, I did a little analysis last year when they were at the bill stage, and I asked myself, well, hold on a minute. If we're just moving things out of the legislation and into guidelines, what are we really achieving? And it was a fascinating little analysis I did. Indeed, they have done on some respects. They've taken down, let's see, the number of sections in the SPA, which is supported by one regulation, a very important regulation, from 1,041 sections and 21 schedules in the regulation. I had to tell you it was big, I warned you. Okay, to 530 sections and 39 schedules in the proposed suite of the Planning Act, and also a Planning and Environment separate court bill, and the most essential regulations. Looked like a major hit, and well done to them. But hold on a second. Have a look at the comparison of pages. 666 pages for the SPA and its accompanying legislation and regulations. 770 for the Planning Act and its essential accompanying regulations and statutory guidelines. Furthermore, because it's such a fundamental change to the legislation, we're going to need a Consequential and Other Legislation Amendment Act. That adds another 375 pages or 697 sections. So my question is, are we there yet? Have we really changed things or improved things? Change is constant, perhaps progress is slow. We'll leave that there for today. Thank you.